Well, I'm going to commence. There's still a few stragglers, but this is a recording event, so anybody who doesn't catch up with it now can see it later. So introduce myself. I think everybody I know just about on the call. Tim Major from the Thames Valley Chamber of Commerce, and I look after all members in Swindon and down through West Berkshire and towards Reading. So for those I don't know, good morning to you. It's nice to see you. Thank you for joining me and the team from PwC today for, I suppose, our ongoing theme for the Chamber about restart, rebuild and renew. We've kept the subject matter, as you know, the last few months really quite topical as we've changed to webinar and this type of style in terms of Zoom meeting and things like that. Did in April and May about 2 webinars a day as the world kept changing almost daily to meet the current pandemic crisis that we've seen across the country. But I suppose about using the theme of restart, rebuild and renew, that's very much where we are today. And I'm just going to, if you've not looked at our events list, this is a self-advert coming up now because I'm actually just doing 3 more events coming up. So please have a look at anyone wants to come along on Thursday. We've got Robert Buckland, MP and QC, and the Government Justice Minister. So if anybody would like to hear him talk, and I've got 6 businesses in the room with him, and everybody else can ask questions, albeit they'll be in a similar style to this. But if you would like to be on that particular event, just email me and I'll arrange for you to get some joining instructions. It will be a Microsoft Teams meeting that day. Okay, and then on the 10th of July, I'm only went on the events diary yesterday. I'm hosting a West Berkshire join up, so I've got some West Berkshire members on today, so do have a look at that one. Doing it slightly different rather than the opportunity for everybody to speak. I'm going to do like small interviews, so do have a look at that one. And similarly on the 17th of July is the Swindon one, which again I'm going to do it by rather than a smaller interview style, just people talk about their business more. That self-advert's done. But let me introduce you to the top table from PwC, which you're probably aware obviously is one of the world's largest service companies and international. $42 billion worth of turnover. I read that from your website team, so I know that clearly to be true. And you have 276,000 employees across the world. But more importantly, across the Thames Valley is where you are. So we're really delighted to have you here today. You've got Matt Bridger, who is picture, actually not doing him justice on the screen, but it's giving you a wave now. Leads the employment team in Reading, deals with PAYE, dispute resolution, and the coronavirus job retention scheme, basically looking at what comes next, which I think is important today. Simon Herbert is the reward and employment team UK tax advisor, advising on tax and NIC, and I'm sure a lot more than that, Simon, so good morning to you.
Good morning.
And last but by no means least, Marmare Barekati, who is a solicitor in the employment team, also at PwC. So without further ado, just to explain, if you have questions after the presentation, you'll see that additionally on your screen is a Q&A box. So if you would like to put any questions that you have in there, then I'll do my best to ask them to the team. And if we don't know the answers, then quite honestly, I'll tell you so, but we will get back to you. So I hope that's a fair representation. Without further ado, Matt, Marmare and Simon, over to you guys. And Simon, don't forget to unmute, but there we go.
Brilliant. Thanks, Tim. Maybe if we just say a quick brief word about each of us. So I'm based in the Reading area, covering, as Tim said, the Thames Valley, and we cover right the way across that Thames Valley area, all angles of employment tax. And you'll see we've split up the session today to cover a couple of different areas around the background on CJRS, along with some really practical comments. And just a bit of housekeeping. We've mentioned there Chatham House rules. If you want to raise any questions, we'll keep them between us in terms of what those questions look like, but also you'll have our contact details afterwards if you want to talk through anything further. Marmare, good.
Yeah, thanks, Matt. So really nice to meet you all, albeit virtually, and thank you for having us here today. So just to introduce myself, I'm Marmare. I work in the employment legal team based in London, and we kind of cover a variety of employment law work, kind of full ranging, but most recently have been spending quite a lot of time trying to navigate the CJRS and working closely with Matt and Simon on that. So thank you for having us all today.
Thanks, Marmare. Good morning, everybody. I'm Simon Herbert. I'm also Senior Manager in our reward team in the Thames Valley, covering the South area as well. And pretty much like Matt and Marmare, been very busy on all aspects of UK employment tax compliance at the moment, but also particularly around the furlough and job retention scheme in the last few months.
Brilliant. So if I just kick off in terms of where we are and what we're seeing. So as Tim said, it is a phenomenally different world over the last few months in terms of what we're doing. And just as a quick reference, Tim mentioned about 24,000. We've got 24,000 people in the UK. All of those are working at home at the moment. And I'm sure you on the calls have been adjusting to those sorts of working challenges as well. But also seeing colleagues and clients and friends who've been impacted by the furlough scheme. So it is a really different time, really, in terms of where perhaps we thought 2020 would be going. Now, I suppose, zooming in specifically on that furlough and the coronavirus job retention scheme, it is a phenomenal scheme that the government's put in place to help protect jobs and livelihoods. But as with anything, it comes with some practical challenges. And some real challenges about applying it to each workforce. We've drawn out there around holiday pay being one of those, and in particular, when this fell in terms of April and May, having 4 bank holidays in there, there's a bit of challenge around getting that part right for people who are furloughed, but also employment law challenges, and Marmare will cover those specifically shortly. And as you'll have seen, every employer from the individual one person businesses right the way up to the biggest businesses have been grappling with how to do this, and also how it works for their business. So you'll have seen a huge variety perhaps in the media around whether we top up or not to 100%. We've seen businesses really struggle through this time, but also there are implications around actually the wider operational and control side of businesses. Big one that I think worth mentioning is around transactions. So one of the things we've seen as a firm is that we think that the way out of I suppose this significant dip and recession will be a deals-led move outside of this. But one of the things which I think is really worthwhile mentioning is in those deals, as we see things starting up already, CJRS and furlough claims will be something which is commented on. So these are material numbers that a lot of businesses are claiming to keep them afloat, and the goalposts have moved a bit. So looking at the time period for claims, it's gone back. HMRC have updated this to be 6 years back from claims being made. So it's a significant piece of compliance for businesses to stick with as well. We thought we'd just flag at the bottom there, and we'll continue to do this throughout, some learning so far. Big one around consulting and taking advice, and particularly documenting decisions. We mentioned that 6-year point. Any business will see evolution of people and the way things are done, and actually documenting what you're doing, PDFing records of guidance and legislation that's being used will be vital, so that you can have a really clear backup for what you've done. And businesses are now starting to plan for navigating from lockdown, and we've seen that throughout the retail world in particular. Greggs have been widely mentioned in the news about opening up their stores, McDonald's, but also we've seen a number of businesses voluntarily either returning their grants. So we had Games Workshop mentioned in the media, but also businesses not claiming when they were planning to. So IKEA was mentioned. I think we're going to see a huge change as we go through this. I just go through. It's worth just pulling out the timeline really in terms of what's happened. And I mentioned earlier, this has evolved at pace, but it has been incredible what's been achieved. This scheme, the Coronavirus Job Retention Scheme, was designed to reimburse costs connected with employment that arose from COVID-19. And as we speak, just as people are unwinding furlough, the scheme is supporting about a quarter of the UK workforce. Completely unprecedented times, and I know that word's been used a lot recently, but it genuinely fits this. About 8.9 million employees are furloughed. When you think about that pace, the 20th of March was when the scheme was announced. There was various levels of building up towards employers getting guidance for what is furlough. It's something a lot of people have never heard of, through to how do I furlough someone, through to being able to claim. And that started on the 20th of April. So literally within a month, they built a portal for businesses to claim. And we've just had recently a further extension right the way through to October 2020 for claims. There's a really important point to raise, which is about 1st of July, next week. The CJRS 1 scheme closes effectively, and we move into flexible furlough. And that means that the government are looking to kind of wean businesses off of furlough and the grants, but also move towards businesses contributing slightly more. And the other side of that is that there's a pause on what people can claim. So the big date, which I think hopefully everyone's aware of, that the 10th of June was really flagged as this big date where if someone had not been on furlough by the 10th of June, which means that by the 30th of June, they'd have met 21 days of being on furlough, then they are no longer valid for being part of a claim. So it's a really key date in the unwinding of this scheme. The final point I just want to draw out was actually how is this evolving as we navigate from lockdown into more normal working practices. And I think the important thing here is that we have got a significant shift, I suppose, in terms of what businesses will be expected to pay. So July is exactly the same as the scheme has been up till now, with businesses being able to claim employer national insurance, a relative part of pension contributions, which is the very minimum for auto enrolment, and up to 80% of wages. And then from August, we start to see employers having to pay that national insurance and the pension contribution. And then September and October, we see a gradual reduction in the amount that the government will be paying towards the wages. Now, I think just before I pass over, it's important to say that that is not the employee will get less. It's purely, so you'll see on that bottom row, the employee must continue to get at least 80% of their income. But it's just that the government will only pay 70 and 60%. So it means that employers will need to fill in that gap. I'll pass over to Simon now.
Thank you, Matt. So in summary, the job retention scheme has been widely used by employers, and I think, as Matt said, we're going to start to see the gradual reduction in support by the government in the coming months, and up until the scheme closes at the end of October 2020. From 1st of July, as we've just heard, we'll have the ability to flexibly furlough staff, with the employee being partly paid by the employer and partly paid by the government. And as we come onto that flexible furlough scheme, it's no doubt, certainly from what I've seen already, it's going to present another layer of complexity for employers in the situation of having to capture people, maybe where they bring them back flexibly, having to capture employees' usual hours versus those that they've actually worked whilst not on furlough. What I want to do now is just talk about some of the practical considerations to think about. However, some of the key points to highlight on the back of the overview that Matt gave, and just to reiterate again, so from the 1st of July, employers will only be able to claim a grant for employees that have already been furloughed for the 3 consecutive weeks between March and June. So that important date Matt mentioned about the 10th of June. However, it's worth noting that we do have some easing for people who have come back from certain statutory leave like maternity or parental leave. That date won't apply. We've seen HMRC start to push back where over the last couple of months they've maybe given deferments of tax and NIC payments. They've said that they will not give a deferment from the end of June for amounts that relate to those under furlough. So that's an important aspect to bear in mind. What we've certainly seen as well in terms of making claims, there can be challenges ensuring that the information that is being provided is complete and in the right format. We have seen HMRC reject claims, even for things that are just not as simple as the information being in the right format, and then that's led to then delays in the funds coming through to the employer. We've also in the last few weeks seen a lot of information coming out from HMRC around how they intend to enforce compliance for those who have overclaimed, and they've confirmed that we can expect to see penalties for errors that are linked to behaviour and where reasonable care has maybe not been taken in putting claims together. And finally, I think Matt touched on that at the beginning as well, we need to think about the interaction with other areas. So say senior accounting officer provisions, where somebody will be signing off their certification to say they have reasonable process and controls in place around tax data. So how does that interact with those provisions? Matt, next slide, please. So in terms of some of the key practical considerations we've seen, as we mentioned, the drop retention scheme will close from anyone who hasn't been furloughed for 3 weeks by 30th of June. So from the 1st of July, under CJRS 2, as many are referring to it, you'll only be able to claim for those furloughed previously. 10th of June being the key date for people that you're going to be put on furlough and to qualify the scheme from the 1st of July. One other point, talking to a lot of clients around at the moment, is it's important to note for those periods up to the 30th of June, you will only have up until the 31st of July to make claims for employees furloughed up until that date. And I know I've certainly got a number of clients who've still got claim that they'll need to make for that period at end of June. So it's important to bear in mind that end of July deadline. Very much recommending that where this scheme has just evolved so quickly and we've had many different versions of guidance, it's very, very worthwhile documenting the thought process around, first of all, why companies have taken access the scheme in the first place and the thought process around that and how they were affected by COVID, but also in terms of how the claims have been put together themselves, and certainly where we've seen changes month from month or different guidance, certainly around areas I've seen recently like overtime, how that guidance from the revenues evolved, worth documenting, maybe printing copies of the guidance that's been relied on in putting the claims together is worthwhile thinking about. Next slide, please. So the key learnings really to draw out that we've seen and I've seen from supporting clients and businesses thus far in making their claims, point I've just made really around documentation, but not just documentation around how you put the claims together, but also the documentation that you've got with employees, particularly as we go into CJRS 2 around what hours they may be coming back flexibly, so that they have signed up to these agreements. Certainly in the last few claims I've been doing with clients, there's been a number of issues around the base data that's being used in the claims, so maybe particularly around what elements of pay and are the correct components being included in the pay calculations. For example, there's assumptions to make and take around overtime, excluding items such as bonuses, and how even people have decided whether they were going to treat their employees as variable or standard salaried method. Again, really important to make sure that's being thought through carefully and then documented. And there are some really useful examples in the revenue guidance that, again, if people can map across to how they've used those to help in their thought process, that's very helpful. And the calculations are complex. The revenue have got a calculator, which is good to help sense check some of the logic, but there's some quite complex calculations, and I think we will see even more of that as we move into flexible furlough. So it's really worth cross-checking back spreadsheets, formulae, back to the revenue examples, because we have seen the revenue delay claims, throw them back where just even simple mistakes have been made.
Sorry, Simon, I was going to say that's a really interesting point, isn't it? Because of the period of the claims being March and April, excuse me, we saw a shift in the thresholds for national insurance and for pensions, also enrolment.
Really good point, Matt. And I think I picked up one last week where, again, they sort of carried across their spreadsheet from March and April, and then not made the changes for sort of different periods in calendar days for May. So really important just to think through the spreadsheet. And what we've seen now is some more guidance from the revenue around how any previous errors or that have been made can be dealt with in claims. I've spoken to certainly people at the start who were maybe thinking about just making adjustments through the next claim. We've got a method that's been laid out by the revenue now about how any adjustments need to be made. Next slide, please, Matt. And then finally, just practical considerations around the claims being made. As I've talked about, we've seen rejections. We've got a different model that if you've got less than 100 employees being furloughed, then it needs to be entered on a line by line basis, whereas when it's more than 100 people, you can complete it in a spreadsheet format. But certainly, again, there's only limited information that the revenue need, and think about not providing too much, because when that's happened, again, that can get the revenue to reject the claim. And we're clear that the revenue will retrospectively look back as part of maybe employer compliance visits going forward about how furlough claims have been made. So it's really important to keep clear records of guidance you are relying on, how the claims have been put together, so that can all be brought out down the line and maybe in discussions with the revenue. So what we want to do next was just pass across to Marmare to talk about some of the legal aspects as well. Thank you.
Thanks, Simon. So in terms of the employment law aspects, I mean, they naturally kind of overlap with quite a lot of the points that Simon and Matt have talked through, but these are some of the areas that we are kind of seeing as key employment law considerations to bear in mind. So one of those areas is continued access to CJRS and the test for claiming. So, as the team touched on at the outset, I think this is, at this moment in time, there is a bit of a pause for reflection from employers as to whether, if they have access to the scheme, does it continue to be appropriate for them to continue to do so if the business rationale for furloughing has ceased. So, we're having some discussions in terms of what we're seeing from clients, and people are reviewing whether the CJRS support is still needed, particularly because, it remains to be seen, and the government have been consulting on quite a kind of onerous clawback regime. And as a result of that, I think employers are treading a bit more carefully, and equally some may have come through this period better than they'd anticipated. Needless to say, that won't be the case for all, and a number of businesses have found this particularly challenging in this period, understandably. But where you have kind of come through that process better than expected, I think there's also the reputational considerations, which we're seeing a lot of people look at. And as Matt touched on at the outset, that's kind of resulting in some people, considering paying money back and having, further consideration on that. So that is something which should be considered, I think, quite carefully at this moment in time. I'd say kind of linked to that, we kind of touch on there the test for claiming, and there's been a little movement there as to what that test is. So, previously we'd seen the guidance talk about being if you're severely affected, if you've been severely affected, and there now seems to have been a shift, and it says if you are affected by coronavirus. So that can give the appearance of perhaps a lower threshold, and it remains to be seen whether that kind of former wording was a test that HMRC would have kind of applied strongly in practice, and whether that's now deliberately been removed. But I think notwithstanding that change, I think there's still a principle that remains that, clients really need to be satisfied and comfortable that they are sufficiently affected by coronavirus such that it would be appropriate for them to make a claim. And they'll need to really carefully record their conclusion and rationale as to why it's appropriate to access the scheme. So having that kind of documented well is really important. So then we move on to selective unfurloughing of the workforce. So, you know, particularly as kind of we move forward, employers are perhaps starting to think about bringing people back, and there are kind of potential issues to think about bringing back some rather than all of the workforce. And that can mean that the basis for selection can prove slightly challenging, because employers will want to observe and ensure business continuity whilst making sure that they observe employment law rights. So that's quite important, because failure to consider those risks quite carefully can lead to potential exposure for employers, such as, you know, potential discrimination risks or other legal claims such as constructive and fair dismissal. So I think naturally, if you're bringing back all of the workforce, then these issues are less likely to apply. But if you are just unfurloughing some individuals, or have this process of selective unfurloughing, objective criteria really needs to be considered, and looking at those factors that you ordinarily would around kind of skill set, you know, ask employers who've expressed an interest in returning to work. You know, a number of factors can be looked at there, which would mitigate some of those potential risks that we touched on. Just alongside that point and return to work, I mean, naturally, again, this will be at the forefront of a lot of people's minds at the moment. And, you know, whilst it wouldn't ordinarily be necessary for the employer and employee to agree that the employee will resume work, because that's more or less the default position, it's likely that a number of employers would have communicated a policy or a process within the furlough agreement as to how the furlough will end, i.e., for example, if employees will be given a notice period, like for 5 days, for example, to return to work. So where there has been an express agreement around return to work, and that's been set out in the furlough agreement or otherwise, that should be followed. Otherwise, it seems it quite prudent for employers to give employees reasonable notice, preferably in writing, that the furlough is coming to an end and that employees will be required to return to work. And you know, that brings with it, and you know, that's perhaps a whole other session, but a lot of considerations around, okay, bringing people back and what does that entail, and you know, primarily health and safety consultation, and ensuring that there's those health and safety obligations that sit in employment law are being complied with, and that you're providing a safe working place for your people. Equally, you know, consideration of any adjustments which need to be put in place for anybody who has you know, been impacted or has been kind of shielding, or for any, for example, disabled employees. So they are considerations to take into account when thinking about return to work principles. So we then move on to consideration of employees with ongoing childcare responsibilities. So, you know, naturally, and as Matt and Simon touching, we've all been working from home, and this has been, you know, quite a challenging period, particularly for those who have childcare responsibilities and trying to balance that alongside work. So that is something, again, which should be considered around unfurloughing employees who don't have access perhaps to the same childcare arrangements that they normally would. Again, some of the potential exposures there around discrimination risks that could potentially arise. So employers will need to tread quite carefully there if they're asking people to return. And I think, you know, what I would say on that, you know, we are obviously moving forward, and as we are potentially seeing some easing of restrictions and some developments in the government's guidance, it might be that more options are available in terms of childcare responsibilities, which may assist that. But that's, you know, something to consider. And again, would really just encourage quite an open discussion in those situations between employer and employee, to ensure that you're applying your policies fairly and consistently, whilst also kind of taking into account any key statutory rights, such as, for example, time off to care for dependents. So that's something which should be looked at when looking at the workforce and return to work. So then we touch on, you know, the impact of furlough agreements, and also any amendments which need to be made, and equally kind of reviewing and making changes to terms and conditions of employment. So it might well be the case that existing furlough agreements were in operation, but now we're reaching a stage where current agreements need to be altered to reflect any return to, for example, part-time work whilst remaining compliant with the CJRS rules. And the team have touched on flexible furlough and how that will operate, and return to work under flexible furlough will require new working arrangements essentially to be agreed with employees, and there's still consideration to be had as to whether that results in an amendment of the existing agreement, or whether it's just kind of cleaner to have a separate new agreement to document that. But again, employers must consider, for example, the issues that can arise when introducing, part-time working or new shift patterns which involve a change to contracts of employment. And there can be, added complexity where the shift patterns or part-time working arrangements are, for example, collectively agreed with trade unions, and that may involve that initial and additional layer of discussion and consultation. So it's just thinking quite carefully when you are altering or, providing new agreements that you're following carefully the CJRS guidance, and also complying with any internal procedures in terms of making changes to contractual terms. So then we come to revise kind of CJRS claim calculations and determining appropriate furlough pay, and Matt and Simon touched on some of these points around employees returning to work on a flexible furlough basis, and employers making a claim will need to specify by both usual and actual hours worked, and that can be really challenging, particularly in the absence of specified contractual hours, or where hours worked in practice differ materially from the contractual hours, or where significant overtime is worked. And for kind of any variable hours workers, there may also be questions of implied contractual obligations, and custom and practice considerations will be particularly key here. So in terms of looking at that and determining appropriate furlough pay, if any changes are being made to those pay arrangements on return, the employer will need to think about the impact on the CJRS position, and also in thinking about whether there's any change to those variable and fixed categories that had previously put in place, and whether different pay elements become relevant for the claim. So we've put national minimum wage considerations on here, and I mean, the reason being is because naturally, and particularly we've been moving at pace with this topic, and it's been ever developing in terms of the guidance and the direction, so that's really been forefront of mind. But national minimum wage is something, I think, which shouldn't be forgotten, and insofar as particularly for employees that are being unfurloughed, careful consideration still needs to be adopted to make sure those employees are being paid correctly according to the national minimum wage rules, and this is particularly in the context of thinking about flexible furlough, which can lead to potential risks from an NMW perspective if not followed correctly, and particularly for those employees returning part-time who may no longer be carrying out salaried hours work for NMW purposes, for example. So that's an area where I think as the flexible furlough scheme becomes more embedded and employers start to look at that, it's just worth keeping an eye to national minimum wage as well. And then just in terms of the final couple of points, so potential consultation processes. So I mean, naturally, as we move forward, and particularly taking stock of how businesses may have impacted, this is something that employers may be starting to think about in terms of potential consultation exercises. And, real care needs to be adopted in relation to implementing those processes, particularly whilst the workforce remains on a period of essentially partial furlough under the flexible furlough arrangement. So, if there are any issues of pooling or selection, for example, then the impact of furlough needs to be handled quite carefully. And then just to conclude on this slide, we then just touch on record keeping. So, Matt and Simon touched on this, and I mentioned it earlier to some of these points, and the real importance of documenting your rationale to really kind of protect the decisions you've made, and records of appropriate communications, agreements and decisions, particularly around unfurloughing and flexible furlough, should be kept for a period of at least 6 years. There has been some variation of reference between 5 5 and 6 years, but 6 years is the timeline that we we're confirming in our discussion. So it's really important that that is looked at, and that will also help the employer defend. Unfortunately, hopefully that would never be the case, but should they reach any kind of subsequent challenge, either from HMRC or employee claims, that can be a really kind of useful reference point for employers to document the decisions which were taken at the time. Okay.
Perfect.
Thanks, Matt.
So we've got 2 follow-up slides, which I think are just helpful references, hopefully, for everyone in terms of what else to think about aside from just the furlough scheme. And please do take these thoughts away with you and think about whether they apply to your business or yourselves. The first one is around a lot of people are forced or being pushed to work from home a lot more than they would have done ever before this. And there's been a number of easements to of particular note. Firstly, employers can pay their employees up to £6 per week free of tax and national insurance to cover those additional costs of working from home. So that might be things like additional data for your broadband, or the cost of heating or eating, or whatever it might be at home. So that's just a round sum allowance that people can use. And secondly, if people are needing additional things to work from home, and the key thing here is that it's specifically because you need it to work from home, not because you'd like a 70-inch flat screen, but actually if something is needed to support working from home arrangements due to COVID-19, the employers can provide this without any kind of tax consequences, which I think is a fantastic easement from the government, really, in terms of supporting employees working from home. And the final one, and I think it's a challenging one, because you can imagine how this applies. So where someone has a company car provided by their employer, they'll be paying tax on that, but they've had a company car sat on their drive potentially for 3 months, not used. And typically, company cars can be quite an expensive benefit to have. Now, HMRC have said that they will have some specific examples where a company car benefit wouldn't be reportable, and they've given some examples on their guidance. But I think it's very difficult to meet those in terms of having very clear keys handed back to the employer, so you genuinely can't use the car, odometer readings, photos, those sorts of things. So I think there's almost a pause point. If your employees are coming to you and saying, I've got a company car, but I haven't used it for 3 months, can I not have it reported on my P11D? I think you just need to pause and think, what's the right answer to that? There is a plus side from April 2020, just as a final flag. Car benefits for electric cars from April 2020 have been reduced to 0 for newly registered cars, 0%, and 2% for those previously registered. So actually there is perhaps a push towards that kind of greener economy going forwards, which hopefully is a small positive. Simon?
Yeah, thank you, Matt. And just a final slide to finish up on. As Matt said, we've got the year-end traditional sort of employer compliance obligations, all due in the next couple of weeks, and we haven't seen any extensions, and very unlikely we will now, around P11Ds needing to go out, pay-as-you-earn settlement agreement compliance. So all of those normal annual returns still need to be completed in the coming weeks. But I think that they brought an added complexity this year. Given some of the areas that Matt's talked about, with different things being reimbursed, or the challenges around maybe questions from employees on company cars. So certainly seeing employers and clients thinking this year more carefully around, well, how do they access some of these records, given that people aren't particularly maybe in the office at the moment? How do they get these forms prepared? How to treat certain expenses, and I've listed a few on the slide, about the areas that are most common. Also seen some challenges around people making sure that expenses policies are being communicated, updated, so employees know what they can or cannot claim, and also just resource constraints at the moment in terms of gathering data for some of those routine entries that are required on P11Ds. for example. So it's still quite a challenging time, but it's still important to be thinking about those normal end of year compliance obligations around share schemes as well that still need to be reported in the coming weeks. So that ends the formal part of our presentation, and I believe I'm going to hand back to you, Tim, just to see if any questions have come in, and thank you everybody for listening.
Thank you very much, team. There's an awful lot to consider, and I suspect there's going to be more questions that people will think about post the event. So your details I've got, so if anyone feel free. I suppose one question that's come up a couple of times is, I suspect this is going to go to Marmare, actually, is around if you've got employees who actually are sort of putting up objections to returning, whether it's health and safety re-particularly, you know, where literally people have been tucked away for 3 months, and naturally you know, when you re-emerge back into the world, how can that be tackled in the workplace by employers?
Yeah, no, it's a really good question, Tim, and one that I think a lot of people will be thinking about. I mean, I think a key consideration will be kind of understanding the reasons why and what sit behind that. So if an employee is, you know, refusing to come to work, and you know there's no kind of negotiation there, I think it's important to understand, you know, what does the employee, you know, reasonably believe that there's a threat to them, which is, and we've kind of seen some of the language used, that's kind of serious and imminent, and that can't be reasonably controlled. And I think that particular phrase is quite important insofar as, so for example, if you've had somebody who has been shielding, or who lives with somebody in a vulnerable category, I think, you know, they are some of the examples which come to my mind straight away around. You can see there why the concern may fall, and they may think, okay, well, the employer has assured me that they carried out a risk assessment, that kind of health and safety has been, you know, a process has been followed, and the office is, let's use an office as an example, been set up to manage those risks. But notwithstanding that, you know, my personal health concerns, or the health concerns of someone vulnerable I'm living with, are still a key concern. Now, I think in those situations, I think employers need to be really careful around imposing and kind of enforcing that people must return to work in those circumstances. I think, you know, there's one issue of kind of doing the right thing there, but also around, you know, potential exposure for the employer. I think that does carry with it risk. Saying that, you know, if there aren't those factors that arise, then I think, you know, there's more scope for the employer to say, well, you know, I've carried out a risk assessment and, you know, I've followed all the protocol. Well, this will continue to be monitored. I do think this is a safe working environment. You know, what's the particular concern there? Because I think, and having that open dialogue with the employee can be quite helpful in that situation. And particularly if there are then others returning to work, I think it's kind of understanding what the concern is from that particular employee. So it's likely to be quite fact specific. I don't think there's a blanket canvas for employees to simply say that they won't return to work because of concerns. However, you know, real care needs to be approached with this. I think one, because this is all quite untested. You know, if somebody challenged this from an employee perspective, it remains to be seen how strict an approach a tribunal might take. So that's one point to consider. But secondly, and I guess kind of perhaps more forefront of mind, is those kind of categories of people who have, you know, I use the example of shielding or living with others in vulnerable categories. There may be kind of legitimate concerns why they think, notwithstanding the measures in place, there's a kind of serious and imminent threat of their return to work, even with those. So yeah, they're just some initial thoughts on that.
So don't force them to come back without a process, I guess, is the
Yeah, I think the process is really important, and I think kind of having done that risk assessment internally, so you can be kind of comfortable from an employer perspective that you've followed and taking into account the guidance. And there's obviously been guidance which has been issued for respective industries, so taking a look at that as well and saying, you know, am I comfortable I've followed all of these? I think that's a really good kind of first step to give you a bit of comfort, both from the employer side and on the employee side.
And how do you think on the discriminatory part of it, where some people are returned from furlough and some aren't? How do you balance that sort of almost that judgment of why I'm bringing Fred back and not George?
Yeah, so I think, you know, if there are, if you're bringing back just a proportion, I think it's about adopting kind of really objective criteria so that there's a real clear rationale as to why you've done that. So, for example, you may say, well, the kind of X amount of employees, their skill set and part of the business they work in, that's why that's one of the factors which is really important why I need to bring those individuals back. If another part of the business isn't quite up and running yet and the employees allocated are specifically allocated to that part of the business, then it may not be reasonable for them to return. So I think it's kind of making sure that you base your decisions on kind of fair and objective selection criteria. If you are just unfurloughing a proportion of the workforce, and making sure that's really clearly documented so you can justify your decisions if they are challenged, for example, subsequently by employees.
And okay, this is one for I think Matt and Simon. This one is around in terms of tax. Which do you think is the potential liability that's coming down the line, where everyone should be most of all aware of coming for the next tax year? Where do you think perhaps business could be most exposed?
I suppose just picking up maybe, Matt, on a couple of the discussions I was mentioned in the presentation. You know, I have just seen so many issues with some of the claims that have been put together, that people have obviously, you know, tried to put them together quickly with very complex rules. So I can certainly see, you know, challenge down the line from the revenue in terms of trying to understand how people have put together their claims. You know, where sure you've seen as well, Matt, isn't there some real complexity certain around, you know, even the national insurance, the pension contributions you bring through, which need some real careful thought, and will need even more so as we go into the flexible furlough scheme from 1st of July.
And perhaps linked to that, slightly less tax related, but in terms of we saw when all this kicked off, there's a number of big brands or, you know, millionaires or billionaires who own businesses who are being criticised for potentially claiming. So there's that kind of moral or fairness judgment, which is perhaps a media judgment rather than a realistic judgment. But with businesses who are handing back funds or not claiming funds they were probably entitled to, there's probably a question about, what does severely impacted mean, which is this phrase that was used in the initial guidance and the initial legislation, to say, actually, was the business or any business right to claim it in the first place? And obviously that's a really sweeping, difficult judgment call. And I'd put my hat on the fact that actually the vast majority of businesses have been severely impacted and really, you know, absolutely shockwaves through business. But I think there will be some questions that will be raised, particularly in the media, about why has this billionaire been claiming for their business? Just naturally, that will come up in the media, I think.
Moving away from some of those schemes to perhaps some of the loan schemes, do they have an impact, tax implications for the receiver?
So I think there's three levels of loan scheme, and I wouldn't want to go into too much detail, but when people sign up to them, there are a number of, I suppose, caveats or clauses that are put on those businesses. And I think we see it around furlough as well. And you know, when businesses are making claims or grants or loans from the government, what's not expected is for them to be paying out big dividends or big bonuses or other significant payments or extractions of capital. So if a business has benefited from a £1 billion loan from the government, we wouldn't expect that to be paid out the next month in a massive bonus spree, because that's not the right thing. And I think being very careful. Marmare, have you seen anything else around the kind of loan side of things?
No, I can't say I have seen. I haven't been quite as close to that, so not beyond what you said, Matt.
I think Matt had picked up as well, didn't it? Something else that I referred to, that where we'd seen in the past that early on the revenue agreeing to maybe time to pay type arrangements and deferrals of monthly pay as you earn and NIC. Once it became apparent that some businesses were still applying for those deferrals or inadvertently had just agreed deferrals, but they were then furloughing people, the revenue were quite quickly then to clarify that actually they wouldn't expect to be still agreeing deferrals, or those deferrals applying to the furlough element of the pay as you earn and NIC. So interesting sort of theme still coming through there.
And I think that this is just purely my thought, but I would imagine that there will quite quickly be freedom of information requests being made to the government, because this is government public funds, to ask who has benefited from either the loans or the government-backed loans. Effectively, some of these are completely backed by the government, or the furlough scheme. And again, I think we're likely to see some big names be either criticised or praised for how they've approached this.
Perfect. Okay. Any final takeaways for everybody to be aware of before we finish our webinar today? Anything overriding that you would say as a takeaways that all businesses should at least consider whether they employ one person or more?
I think the one theme which I think is phenomenally important, I think we've all referenced it throughout, that is the guidance, so that businesses will be using that guidance to work out their claim, and it is changing weekly. Some of the phrases are changing, some of the wording is changing. So if you're preparing a claim, be it for 1 or 100 or 1,000 people who are furloughed, please take a PDF of it at the date you're making the claim, so you've got a clear record of what you used.
Good advice. Document.
Document. Absolutely. And just as we've said, it's only going to get more complex as people maybe come back on a part-time basis and under flexible furlough from the 1st of July. So there's just lots to think through as you're putting together claims, or as Marmare's talked around about thinking about which people maybe do come back or don't come back. Some really important considerations there.
Perfect. Well, everybody, thank you for your time this morning, and I hope that everybody who's on the webinar today was able to take some useful information back, whether it's for themselves or businesses that they advise themselves. Should you want to say talk to everybody, please feel free to come through my good self. I'm quite happy to be the conduit for introductions and vice versa. But I would just thank you for your time today, everybody who's out there listening to the call, and I look forward to seeing you hopefully at some of those meetings that I mentioned to you before. But to Matt, Marmare, Simon, thank you ever so much, and we look forward to seeing you again, perhaps in real life next time.
Thank you, Tim.
Thanks, Tim.
Thanks, Tim. Thanks, everyone.
And thanks on the call, everybody. Thank you very much.
Tim, just out of interest,
Just got one person on the call.